Hello, everyone. Thanks so much for joining us today for this special training session on the new proposed DOJ rule regarding attorney discipline. Today, you'll hear about what the rule says, how it changes the current regulatory environment, and most importantly, how to submit comments and strategies for submitting comments. We have several amazing panelists today. We have Trish Rich, who's a partner and co-chair of the legal profession team at Holland and Knight. Sterling Howard, Senior Vice President, Development and Engagement, Lawyers for Good Government. Lauren Stiller-Rickling, Executive Director, Lawyers Defending American Democracy, and Julia Sisbala, Senior Director for Oversight, Regulatory Affairs, and Strategic Initiatives at Democracy Forward. And I am Mary Smith, President of the Task Force for American Democracy. And the one thing I want to comment on before we turn it over to Trish is that all of these organizations are coordinating together. We all have a shared interest in ensuring that lawyers adhere to ethics requirements. I know myself, I am a past DOJ attorney, and I know that during both two stints at Department of Justice, I was still subject to the states in which I am licensed regulatory schemes. So with that, I will turn it over to Trish to talk about what does the rule do and how does it change the current disciplinary schemes for attorneys?
Sure. Thank you so much, Mary. So I'll just start by talking, basically about the way lawyers are regulated. And that is on, as I'm sure most of you hopefully know, typically on a state by state geographic basis. So I'm a lawyer in Chicago, but I am also licensed in Michigan, Arizona, and New York. And so I am subject to the regulatory oversight of those four, bar regulatory offices. Those are arms of the Supreme Court because of the inherent powers doctrine. In each state, the Supreme Court of the state has the inherent powers to exclusively regulate the practice of law, and the lawyers and the judges in their state. So you start with that general overlay that's your disciplinary body. So in Illinois, for example, our Illinois Supreme Court is the one that, writes, adopts, amends our rules of professional conduct. They also, the Attorney Registration and Disciplinary Commission, which is the Illinois version of the bar regulator, which every state has, right? That's an arm of the Supreme Court. So when they are investigating or prosecuting or disciplining attorneys, they're acting at the direction of and under the Supreme Court in the state of Illinois. And I use Illinois as an example because that's my home state, but every state pretty much is set up like that. California is a little bit wonky because their legislature has like a little more power to do some things, but they're a bit of an outlier in that respect. So what we got, was it 2 weeks ago now? Time has no meaning anymore. Is this proposed rule, which would give the Department of Justice through the Office of Professional Responsibility, we call that OPR, the first opportunity to review state bar complaints against current or former DOJ attorneys for conduct taken in their federal roles. So for lawyers that are, employees of the DOJ, instead of getting complaints that are kicked to their state bars. So for example, if you're a federal prosecutor in the Northern District of Illinois, instead of that complaint going to the ARDC, which has the regulatory power to regulate attorneys in the state of Illinois, it would go to OPR. It would also allow when a state bar, so just to run out this Illinois example, if the ARDC opened an investigation or received a complaint about an Illinois lawyer who was a DOJ employee, the DOJ could ask the bar to pause its investigation while the DOJ conducted an internal review. The DOJ could choose not to review the matter or could start and not finish a review. And if that happens, I think the proposed rule provides the state bar could proceed as usual. But of course, that could be a lengthy process that takes a long time and, functionally could usurp power from the state bars, regulatory offices, which are really, again, just arms of the Supreme Court of each state. So, if under the proposed rule, the DOJ completes its review and finds an ethics violation, the state bar would still retain full authority to impose discipline, which could include obviously suspension or disbarment. And theoretically, the rule is not supposed to change the way ethics rules apply. The DOJ attorneys should still remain subject to the state rules of professional conduct to the same extent that all lawyers would be. And I'll say the DOJ has really described this as a procedural coordination measure, and not an effort to take disciplinary power away from the states. But I think functionally it does allow the DOJ to, stop, delay, or interfere with the regulatory power that any state bar regulatory office would have over the attorneys in its state. So some of the core ethics concerns, of course, are that, the ability to delay that process, because it inserts effectively this new federal review process that doesn't have, deadlines or anything. And so there's some concerns that have been raised around that it could effectively weaken or block enforcement of the rules of professional conduct through the state bar regulatory office. It also could potentially blur the lines of employment discipline and licensing discipline, because here the DOJ is like actually the employer as well. And the state bars, if you read the enabling statute of any state bar regulatory office in the country, the first thing it's going to say is, we're here to protect the public, right? That's the charge of the state bar regulators, is to protect the public. And mixing that process in with the DOJ process gives the DOJ a significant amount of discretion and really like shifts the what the process has historically been about. You also have like other, I think, collateral issues thrown in there, which is, even if we're applying the same ethics rules, different decision makers could really interpret those rules differently, which increases sort of the risk of inconsistent outcomes, which is one thing that our bar regulators try really hard to do, is like treat like cases the same. In Illinois, in fact, that's one of the charges of the review board. So that intermediary level is to like look at all of the cases that came up from the hearing board and make sure they all kind of look the same, that people are getting treated fairly and consistently and predictably for the same kinds of infractions. And then obviously, critics of this proposed rule argue that the rule really can undermine public confidence by shielding DOJ attorneys from timely and independent state bar scrutiny. So especially in what would be politically sensitive cases, as we have seen. So there's a number of federalism issues as well, but I've been going for about 10 minutes, and so sometimes people want to hear less about legal regulation, and so I'll be glad to stop there and turn it over.
Well, great, Trish. That was a great introduction. And the one thing I failed to mention is this rule was proposed for comment on March 5th, and the comments are due on April 6th. That's why we did this webinar so quickly. But we did get one question in the Q&A for you, Trish, where you said that the Office of Professional Responsibility at DOJ can, quote unquote, ask the state bar to state its investigative proceeding pending OPRs. What if the state bar denies the request and
Yeah.
just moves forward?
It's too early to tell, I think, but I believe the state bar will not be able to move forward under what the DOJ is planning. But it's a little early, I think, to tell. So I think the concern is that this really usurps a lot of authority from the state bar regulatory offices, which are independent, right? I mean, there's a reason we have the inherent powers doctrine, and that's to make sure, you know, lawyers and judges roll up to the Supreme Courts in each state, and that the Supreme Courts are charged with, number one, um, regulating the practice of the law in a way that's independent from outside influence, right? That's why we have Supreme Courts regulating lawyers instead of legislatures regulating lawyers who may be, you know, subject to outside influence. So it's kind of that same principle here is like if the DOJ, who's an employer, is doing it, and the DOJ that's, you know, closely tied to the legislature and the, you know, the legislative process, is weighing in on the regulation of attorneys, that's a serious independence issue. And so obviously that's one concern. I think with the DOJ, again, it's just a little early to tell, but I think what they're contemplating is they would actually be able to delay and interrupt that state bar process.
Well, and one other question for you before we turn it over to Lauren. I know you do this for a living. This is your area of practice. Have you seen in your experience problems? Because obviously there have been decades of DOJ attorneys who are licensed by states. Have you seen this being a problem in the past?
What do you mean when you say this?
A problem with, I guess, the disciplinary proceeding that OPR might do at Department of Justice versus a state's disciplinary proceeding interfering with each other with a DOJ attorney's conduct.
I've not seen something just like that before. I mean, this proposed rule, in my experience, is novel.
Well, that's great, Tris. Well, with that, I will. That's a good answer.
You're
I
you're
will.
still you're still a nonprofit, right, Mary?
Yes, we
Okay.
are a
All right.
501(c)(3).
All right.
I will turn it over to Lauren from Lawyers for Defending American Democracy, and I know they sent out an alert as well on this rule. So, Lauren?
Thank you, Mary. And Trish, I have to say, two lines I will be quoting that this is novel and that time has no meaning anymore because time has no meaning anymore. So absolutely true. I just want to say a few quick words by in way of starting about LDAD, Lawyers Defending American Democracy. For background to this, we were formed as a nonpartisan, we're non-political, nonprofit organization, and our goal is to galvanize the legal profession into taking action to protect democracy, the rule of law, and our justice system. And we do that in a whole bunch of ways, special projects, calls to actions, articles. But the major goal is helping lawyers understand and the public understand what is at stake and why it matters. We've been doing a lot of amicus briefs, as all of us, I'm sure many organizations are doing, because there is no end to the litigation that we're seeing. And relevant to this conversation today, a big part of what we're doing, and we help to pioneer this, is to do very meticulously researched and carefully drafted ethics complaints um, against lawyers in public roles whose alleged breaches have caused harm to our courts, to the justice system, to our profession, and to the public. And we have to keep that in mind when we hear this talk about, you know, weaponization of the disciplinary system. There is no weaponization of the disciplinary system. We are talking, and when we look back at ethics complaints filed against people who, like Rudy Giuliani, who is now disbarred, and we were very involved in that, and John Eastman, who's now suspended, and his disbarment is pending. These are people whose harm is to essential, fundamental aspects of our core democracy, the right to vote, and the rule of law. So they're serious challenges that are part and parcel of this conversation. And part of what we are concerned that DOJ is really trying to interrupt is a function of the disciplinary system. One other aspect relevant to today is that we have an initiative called Meeting the Moment, where we are engaging lawyers throughout the country to reach out to their communities and their networks and their bar associations and their faith communities and the public to explain what is at risk in this country today and why it matters to each and every one of us. And that is, I think, why we are all here and what we are all trying to do in this moment. When we saw this proposed rule, we knew it was going to be critical to immediately galvanize as many lawyers as possible to respond. I know we're all following closely how many have filed. It's over 35,000. But I hope that we are helping, all of us are helping to inspire hundreds of thousands of lawyers and others to respond to this proposed rule. Our voices need to be heard on this. So when we started, our mobilization efforts included educating our network of Meeting the Moment lawyers on the serious issues raised by the draft rule and asking them to take concrete actions by responding. We issued an action alert to our national mailing list explaining the concerns raised by the rule and encouraged individualized public comments, emphasizing, and I know others will talk about this too, that individual comments really carry greater weight than a form submission would on something like this. And to support these efforts and to make it as easy as possible, we created a centralized resource page on our LDAD's Meeting the Moment website tab that explains the proposal and the defects, provides links and instructions for commenting, offers suggested talking points, and includes, importantly, a sample letter to bar associations, because what we would like to see is for all bars. I mean, in addition to the mandatory bars that may feel they need to step back from this, that's a small proportion of total numbers of bars in this country that ought to be stepping up and speaking about this. And that includes other state bars, regional, city bars, affinity bars, that should be alarmed by this proposal and wanting to get involved and use their voice. So let me just talk a few minutes just about the substantive concerns, the top levels, top line substantive concerns that we are seeing in this. And we developed our objections in consultation with our own accountability working group, who has been involved in these complaints in the past that I just mentioned. They are ethics experts and scholars from around the country, former judges, law professors, and we have been going through this really carefully. And so here are just a few of the concerns. We will also be sending in collaboration with another organization, much more extensive documents. But first, the Department of Justice has not articulated a lawful basis for interfering with state attorney disciplinary authorities. There's no there. Lawyer licensing and discipline, as Tricia just explained, their functions reserved to the states, territories, and District of Columbia. Moreover, the rule conflicts with a federal law commonly called the McDade Amendment, which expressly requires federal government lawyers to comply with state ethical rules to the same extent as other lawyers. Second, the rule would require state disciplinary authorities to wait for DOJ to complete internal investigations before proceeding, and it provides no timelines for those reviews. That structure creates the risk that delay itself becomes the mechanism for avoiding accountability. And that occurs particularly where state statutes of limitations may apply to state disciplinary authorities. So DOJ can, under their proposed rule, they can tell the state disciplinary authority that they're conducting an investigation and then let it lie dormant. And nothing requires closure of that. Moreover, DOJ can set an aggressive and dangerous precedent by preempting the state's role to investigate and swiftly assert their own discipline against a lawyer they choose to actually discipline, particularly those who DOJ leadership thinks are not following DOJ's so-called zealous advocacy requirements to act in accordance with the administration's demands, even if the lawyer has a good faith belief that the position being taken by the government may put that lawyer in jeopardy of violating the rules of professional conduct. So it creates a very odd dynamic in that kind of case between DOJ and a state disciplinary authority once the DOJ asserts its own role and acts there. So what we see is that the proposal allows the DOJ to use this rule as a weapon as well as a shield. Third, the proposal undermines the independence of the existing attorney discipline system by placing oversight in the hands of the same institutional leadership whose own conduct should also be subject to review. Independent disciplinary systems exist precisely to avoid that conflict. So consider what we've seen from this Department of Justice over these past many months, including large-scale firing of DOJ lawyers, allegations that court orders are being violated, questions of weaponized law enforcement, courts bringing DOJ lawyers in, concerns about what representations are being made and whether they're true or not. So there's no basis to trust that an internal process would be used for anything but undermining the longstanding system of lawyer discipline that exists in each state and territory and in DC. And finally, the rule relies heavily on DOJ's internal accountability mechanisms. Yet despite repeated allegations of ethical and statutory violations over the past 14 months that warrant an investigation, we don't know of any actions that have been taken by DOJ's Office of Professional Responsibility. And in fact, ironically, even as DOJ in this proposed rulemaking touts its own Office of Professional Responsibility as why they're perfectly capable of doing this role, they have removed, reassigned, or forced out under this administration most of their senior leadership since Attorney General Bondi began in her role. So clearly, attorney discipline is not a priority for them. So I will pause there. For more information about our efforts and our work generally, we invite you to look at ldad.org and our Meeting the Moment tab. You're going to hear great information from my co-panelists today. And again, the more who engage in this topic, the better it is. This is critical to our profession.
Thanks so much, Lauren. And I will say we did get questions in the Q&A, and I will say that for anyone who has signed up for this webinar, we will send out an email with links to things like that any of the panelists have referenced, like the LDAD resources and things from Lawyers for Good Government and anything Democracy Forward has. So, and then also I will note that the entire recording will be sent out in an email, but it also will be housed on the Task Force for American Democracy YouTube channel, so you can reference it as well. So now I will turn to Sterling Howard from Lawyers for Good Government to talk a little bit about strategies if you're thinking about submitting comments.
I think I shared the wrong thing. Hold on just a second. I'm trying to share. All right. Do we see that? All right. I think I got it now. Apologies. Yeah, thank you so much. And I'm really excited to be here today. As Mary said, I'm Sterling Howard with Lawyers for Good Government. We are a 501c3 nonprofit focused on identifying areas where lawyers can make the greatest impact and specifically mobilizing them to defend democracy and the rule of law, to protect civil and human rights, and to advance environmental justice for all Americans. And at L4GG, we believe that, lawyers specifically have a moral and ethical duty to defend the rule of law. It doesn't defend itself. And we believe that this is not just through routine access to justice pro bono work, but that we also, as lawyers, have a duty to actively participate in the defense of the rule of law and in defense of the Constitution when it is under threat. And so we're really grateful to be mobilizing lawyers with all these other amazing organizations represented here today in service of that. And we know that lawyers today are looking for ways to push back, and not everyone's in a position to necessarily take a large piece of litigation or to sue the Trump administration or whatever it is, that you want to do. But Every licensed attorney in this room does, or unlicensed, I mean, whoever you are, you have something powerful. You have a legally meaningful voice in the federal rulemaking process. And submitting a comment on this proposed rule is one of the most accessible, high impact actions you can take right now. And it can just take a few hours, not months. So let's talk a little bit about what that looks like. I'm sure others may talk about this as well, but your comment matters. It matters because federal agencies are legally required to respond to every substantive comment when they are finalizing a rule like this one. Substantive opposition on the record also makes it easier to finalize the rule and makes it harder to finalize the rule and easier to then challenge later in court, which I'll let my colleague Julia talk about a little later. But, litigation against this rule is only limited to what is on the record, aka what comments are submitted in opposition to the rule. So your comment helps build that record. And as attorneys, your comments carry particular weight, right? You are the professionals that this rule directly affects. Your ecosystem, your work as an attorney is impacted by this rule, whether or not you've ever worked at the DOJ. And you don't have to be an ethics expert. You just have to be a lawyer who cares about accountability. And if you're here today, I suspect that you do. So we've made it super easy. We have put together a comment template specifically for lawyers to use. You can access it at l4gg.org/DOJ comment. This was created in direct consultation with National Women's Law Center. However, as I'll note, this is, I'll get to what's included. What is included is all of the amazing resources by a plethora of amazing experts out there, including all the LDAD resources that Lauren was talking about. We have a direct link in our comment template to the amazing Meet the Moment action alert that Lauren was mentioning because it is so excellent. But think about this particular comment template as a roadmap. It is not a script. It's going to give you some key legal arguments and citations to draw from. It's going to, show you some of those bullet points that Lauren was talking about, like the McDade Amendment, the lack of a timeline that DOJ has to investigate, et cetera. So I'll talk a little bit more about what's included in the template, but just want to make sure that you know that this exists. It is a resource. It is over the next few weeks, it will continue to grow as additional resources such as this webinar. We would love to include the link to this webinar in the comment template afterwards so that you have all of the amazing resources. The more the merrier, and then it makes it more likely that your comment is going to be unique. The more resources we can give you. We do recommend that you plan for a few hours of focused work because this is a substantive legal comment that we're suggesting that you write, and time investment is, of course, worth it. So what are you going to find if you go to l4gg.org/DOJ comment? You're going to find some basic background on the rule, which has been discussed here. You're going to have the link to the regulations.gov, exactly where you go to submit your comment. You're going to get information about how to track your comment from regulations.gov, whether you are submitting anonymously or not. Tips on how to write an effective comment. Template bullets. We also very much recommend that you do not copy and paste. I'll talk about this in a second, but personalized comments are really important. And then additional resources from our amazing colleagues, like the amazing resources that Lauren was just talking about. And like I said, we'll add this webinar afterwards. A couple of the tips that are included in there, I thought I'd highlight now. The most important thing to know is that comments that are largely identical get grouped and treated as a single comment by the regulatory, in this case, by the DOJ. Did I get that right? They are treated as a single comment. And so what that means is personalization is the difference between making your comment a singular unique comment, substantive comment, versus it getting looped into others' comments that are saying similar things. So that piece is really, really important. You'll actually notice on our comment template that you're not allowed to copy and paste from it. That's by design. We do not actually want you using the same language. It's our, I'm sure that there's AI scanning these things now, right, to check and see how close and how similar some of the language is. We do recommend that you lead with who you are, talk about being an attorney, talk about what bar membership you're a part of, your practice area, your jurisdiction. That information can help build this record. But we also, recommend you connect the role to your own experience. Have you practiced in federal court? Have you worked with DOJ attorneys? Have you worked at the DOJ previously? Did you teach professional responsibility? Any of that context is gold for the comment that you'll be writing. And you don't need to use every argument that is on display, either in this template or in all the amazing resources that are linked in it. A focused, like a short personal comment is more impactful than an exhaustive one that's just throwing, all the arguments into one very long comment that is going to look like a bunch of the others. So again, we recommend you do not copy and paste. We recommend you personalize, personalize, personalize. That's why we recommend that this, when you sit down to write your comment, it may take a while. This is legal research. This is legal writing. When you're ready to submit, there is a direct link that you can find in the comment template. You can also find it on LDAD's Meeting the Moment initiative link. The direct link is there to the page on regulations.gov where you can submit your comment. I just want to note, in the day and age we live in, I understand there can be some qualms about submitting with your personal identifying information. The regulations.gov does have an option to submit anonymously. So if you want to turn on a VPN, submit anonymously, you are more than welcome to. Of course, in that case, you would not put some personally identifying information in your, other than maybe you're a lawyer and where you live and what you practice, that sort of thing in your comment. But I just want to note, I want to be honest that is an option. If that is something that you would prefer to do, you can do that. After you submit your comment, you receive a tracking number, and if you included your email for tracking, you will receive a copy of it via email. We recommend taking a screenshot, making sure that you have a copy of what you submitted and what the kind of tracking number is. That way you can actually track it after the fact. As already mentioned, the deadline is 11:59 p.m. Eastern on April 6th, which is coming up very, very quickly. One more step that I'd love to plug, which is after you've submitted your comment to regulations.gov, we ask you to do one more thing, which is we have a form at l4gg.org/track comment, where we ask you to submit your comment to us so that we can help track as a movement, right? How many lawyers took action against this rule. We want to be able to say, right, we can point to hundreds or potentially even thousands of lawyers stood against this rule, which sends a very powerful signal about a united legal profession. It also helps build the record, right, that there is organized bar, using the word loosely, opposition that will be important, when and if this rule faces legal challenge. So that's the information about the l4gg.org track comment is also included in the comment template. And last but not least, if you're here and you're like, this all sounds really great, but I really want to get into some more brass taxes about how this all works and what the APA is and how it relates to writing a comment, I just wanted to put in a quick plug that we are also hosting another webinar next week on this comment campaign that you can register for at DOJ comment, l4gg.org/DOJ comment training, and would hope to see some of y'all there. or just spread the word that we are doing another one next week in partnership with the National Women's Law Center. We'll have our litigation director and APA expert, Amy Powell, walk through the APA process and, what makes a comment super effective, which I think will be really helpful also. But don't wait. We have everything you need between the resources that have already been shared to go ahead and write your comment. So I hope that folks will, go ahead and start that process now.
Thanks so much, Sterling. Well, there two questions came up in the Q&A based on what you said. One, I know you made a very powerful case about why lawyers should comment and why it's really relevant to lawyers. What about non-lawyers? Like, what about comments from non-lawyers? I think they have an interest as well.
Absolutely. The rule of law does not only impact lawyers, right? It is the idea that that no one is above the law and that our system should treat everyone fairly. And what this rule is proposing is absolutely the opposite of that, right? And so I think that what we've created is something that could absolutely be used by a non-lawyer to effectively argue that they want a fair system too, and that attorneys that work at the DOJ, that the state bar discipline processes need to work just as they already do, and that we don't need a change in that system. To put it as Trish put it, a novel change. I don't know if
Right.
I'd invite my panelists to add in anything there also.
Yeah, if anyone wants to add, because I do think lawyers help defend our democracy and hold up our institutions of the rule of law, and everyone, not just lawyers, has an interest in that. And you certainly want lawyers when they're either prosecuting or defending cases to rely on law and facts and to serve the highest ethical standards. So everybody has an interest, all citizens have an interest in that. Next question, you referenced that when comments are submitted, DOJ or other administrative authorities are probably going to be running them through AI to see which ones are similar. The question came in about what if you use AI individually to draft your comment?
Sure.
Do you have any thoughts on that?
My thoughts are, like I would say to anyone using AI, use it wisely and carefully, right? There are there are privacy concerns with AI. There are obviously concerns about what the end product ends up being and how strong it would be. So, I'm not an AI expert. I'm not going to sit here and tell you to use it or not use it. But I recommend making sure whatever you read, or whatever you create, no matter how it's drafted, that it is edited very carefully. I don't know if anyone else would add anything there.
All right, well, great. Thank you so much. Let's turn to Julia now from Democracy Forward about what they're doing and any tips and expertise she can share with all of us.
Sure. And happy to be here. I'm Julia Sabala. I'm the Senior Director for Regulatory Affairs, among other things, at Democracy Forward. Democracy Forward is a national legal organization that advances democracy and social progress through litigation, policy, public education, and regulatory engagement. My excellent co-panelists have sort of covered a number of the important bases here, so I'll make my remarks relatively quick. In terms of sort of future litigation on this rule, I should say I'm not speaking with any specific sort of litigation in mind. I imagine there will be suits, probably many, at least, brought against this rule if it is finalized. I think there are obviously a number of sort of entities with good standing here that are directly impacted, and I expect are eager to sue, but certainly nothing I'm saying here is sort of directly, it's all sort of speculative, I should say. So in thinking about future litigation, the commenting phase is very important, as Sterling mentioned, to sort of help build the record for litigation. the administrative record in a litigation is composed primarily of the comments and the sort of other documents that the agency relied on to issue the rule. And usually the administrative record is all you get in an APA challenge in terms of discovery. So everything that's going to be sort of relied on in litigation needs to be in the record. The fact that there are 35,000 comments on this docket already makes me feel good about, I don't think there'll be major gaps in the administrative record because I know everyone commenting is very thoughtful and there have been some excellent resources shared around. So, but that's always something we think about at this stage when we anticipate litigating a rule, to make sure that every sort of issue that we may want to bring up in litigation is raised in the record. It also helps because then the agency needs to reply to those comments. And so it sort of, helps litigation for that reason too, because the agency will have already been forced to state their response to some of the concerns. One thing I wanted to flag about that actually, and this is a little bit wonky, but I hope a webinar full of lawyers, maybe the wonkiness is okay. In the notice, DOJ says that this notice is exempt from the rulemaking procedures of the APA under an exemption that applies to rules of agency, organization, procedure, or practice. It says that it decided to issue a notice and comment opportunity just discretionarily, but it's not required to because this is a rule of agency, organization, procedure, practice. I think that's incorrect, and I think it's actually important to highlight that because what it's saying is if this exception did apply, it wouldn't be required to do this at all, and it could go on to ignore all of the comments, finalize the rule. The fact that it took the comments out of its own discretion wouldn't actually matter if a DOJ was correct that this exemption applied, because the rule of agency practice, organization, procedure, practice is not subject to the notice and comment provisions of the APA. I think there are strong arguments that this is not such a rule, in part because it has a substantial impact on third parties. But I would, to the extent that is something that is on your radar, I think raising that in comments is useful because we should not allow that to go sort of unanswered. It also, if the APA requirements don't apply, there's a couple other, requirements that attach, like a regulatory flexibility analysis and sort of Congressional Review Act, which may or may not matter here. But I think DOJ sort of was trying to give itself an out if it wants to later on, and I don't want that to stand. Real quickly, I think in future litigation, the very obvious claim, among others, is arbitrary and capricious under the APA. I think all of the things that are already sort of in the comment guides and folks have been raising on this call are going to be relevant to that. So the agency did not, the agency made factual errors. The agency made logical errors. Their legal analysis is off base. This is a departure from longstanding agency practice. All of those things sort of go into the arbitrary and capricious analysis. So it's helpful to highlight them in your comments. I think the harm to individual stakeholders, to, you as an individual, to whatever group you represent or population that you work with, those things are always really helpful to get into the record as well, because it sort of, we can use it later on in litigation to show how widespread the impact will be and sort of various other consequences that the agency maybe didn't consider. I think I will pause there and allow for other comments. I think folks covered all of the rest of the important stuff.
Julia, can I ask a question? One thing that we were kind of noodling on is how helpful is it to in your comment propose an alternative, right? Instead of just saying no to the rule, but like what if instead?
Yeah, I think it's a good question. And agencies are supposed to consider alternatives, and that's something a court will look at when they're reviewing the rulemaking record. I think in a rule like this, it's not an economic analysis where they fail to account, or like, it's sort of a strange rulemaking record in some ways. I think it doesn't hurt to propose an alternative because if it's, a reasonable alternative, then the agency needs to respond to it and explain why that is not an alternative it's going to adopt, and that sort of just opens up more space for them to make logical or factual errors and sort of weakens the record in litigation. But I don't think it's critical. I do think in some rules that are sort of more data-based or economic-based, raising clear alternatives that are based on the sort of evidence that the agency ignored is a very good strategy. It's a little bit harder here just because, this isn't really an evidence-based rule. But it's a good strategy.
Well, go ahead, Lauren, but we do have several questions in the Q&A and I want to get to those, and
Okay,
we
sure.
have
No,
like
I
12
just was gonna
minutes
weigh in,
left.
just to weigh in real quick on that in this particular rule, and I completely agree, Julia, with your analysis in most cases, but I think in this particular rule, I can't, I think I personally would not want us to be giving DOJs that kind of opportunity for here's an alternative we have in place. And I think that's what's critical to emphasize. We have in place a system that works in every state. All lawyers are subject to it. Why are we trying to suppress or get around that? Thanks.
All
Go
right.
ahead.
Well, I do want to cover some of the questions in the Q&A. So one question, and any of you who can answer, although this may be Trish. It says the position taken by the DOJ and the Federal Register said that this proposal is based and consistent with the DOJ memo from 1989. So given what everyone said today, how does this proposed rule deviate from past DOJ positions? Who wants, Trish, you're on mute.
Sorry. Number one, I'll start by saying I was in fifth grade in 1989, so I didn't live through that in the same way as I'm living through this current moment. But I have had a chance to look in that, and I think I think what's happening today is a bit more aggressive, and that's an aggressive reading. I guess that's how I describe it.
So do you think it is consistent with the 1989 DOJ memo, or inconsistent, or is it a little more gray area than that?
I think it's an aggressive position to call it consistent. That's what I would say.
Okay. And then another question, which is, I think, an important question is, I know Sterling and Julia, you gave really great comments on how attorneys can customize their comments. The question was, what kind of tips would you give to non-lawyers? And is there any templates for comments for non-lawyers?
Not that I'm aware of, but I think all the materials stand, you know. I don't think you have to be a lawyer to connect, what Lauren was just saying, right? That there is an existing process of state bar discipline, and that this is getting around it makes absolutely no sense, and weakens, the independence of our whole system. So I don't know that there's anything specifically written, but I also don't think that the materials that LDAT and others have produced are exclusive to lawyers, I guess. What would you say, Lauren?
Thank you. I would add that from the perspective of somebody who is not a member of the bar, what I would be saying is that the system that is currently in place in the state's territory and the District of Columbia exists to protect me.
Yeah.
The system exists to protect the public and for the public to understand and be able to believe that lawyers who are representing the justice system and going into court every day and taking care of my interests are properly licensed and regulated. And if they do not adhere to the code of professional conduct that applies to them, they will be disciplined and disbarred. So that system is for them.
Yeah.
And that's what I
Let-
hope they would emphasize.
Yeah, and let me just add too, I mean, like I said, I was a DOJ attorney. I didn't do criminal cases, I did civil cases. And most of the cases I worked on, I think all of them involved the use of taxpayer money for certain things. And so everyone has an interest in the cases and the activities of DOJ attorneys. I mean, some of the cases that DOJ takes are big defense contracts. I mean, that would be of interest now. Contracts regarding National Park Service, many different things. So everybody has an interest in ensuring that the Department of Justice is acting in the public's interest. In fact, all the cases that the Department of Justice is involved in, just to get, it doesn't have party names in it. It wouldn't say Smith versus Jones. They're all United States versus whomever, or in a civil cases, you know, Smith versus United States. So it's the cases are brought on behalf of the people of the United States. Julia, you were going to jump in?
No, that's exactly the point I was going to make. I mean, just to not to sound a little too idealistic, but the Justice Department attorneys are your attorneys as the public. And I didn't work at DOJ, but I worked at an agency with independent litigating authority, and standing up in court and saying, Julie's on behalf of the United States is sort of an experience that all DOJ attorneys probably have had at some point. And it's, so the public's interest in maintaining the integrity of the DOJ and sort of the ethics, system that applies to DOJ attorneys is just as strong as any other party. I mean, I think this really does have widespread impact sort of on our entire justice system and everyone who interacts with it.
One other question we got was, who is ultimately going to decide if this rule gets finalized? Is it the Department of Justice?
Yes.
Yeah.
Well,
And then,
maybe a court.
yeah. And then one other question was, the 1989 DOJ memo was before the McDade Amendment, which I hope whoever answers also explains what the McDade Amendment is for our audience, which is a material change. Are you aware of any efforts by former Department of Justice attorneys or other people who worked at DOJ to coordinate a single comment? So that's kind of like two questions.
On the second, on the former DOJ, I do know that Justice Connection, which is a group of former DOJ employees, kind of organizing around rule of law issues, they are working, they will be publishing on their Substack next week some points specific to DOJ alumni that they can use in their comments. So once we get those, we'll add those to our comment template in the additional resources section. But I'm not aware if they're also working on a comment for people to sign on to.
And then on the first question that the 1989 memo was before the McDade Amendment, can someone address that?
Yeah, I'll jump in and say that that's right. The McDade Amendment came later, and the McDade Amendment lays out the principle that that I started with, that government lawyers are subject to the ethics rules of the states in which they practice to the same manner and extent that any other lawyer licensed in a state would be. So it's just I discussed that principle, but I didn't specifically say like that we get that from the McDade Amendment.
All right, well, we're hitting up against time. I want to thank all our panelists. I'm so glad we're all coordinating. We all have interest in ensuring that all attorneys, but particularly Department of Justice attorneys, are held to ethical standards. Thank you so much to all the panelists, and I will reiterate, the comments are due on April 6th. Sterling mentioned that they are having another training next week if you want additional information. I will also say that anything mentioned during this call, we will send out on an email with the links as well as a recording of this webinar. And the webinar will be permanently housed on the Task Force for American Democracy YouTube channel. And the Task Force for American Democracy, we're here to mobilize lawyers and the general public to uphold the rule of law This year, we are also taking a laser focus on elections. Our next webinar will be on April 1st, and we will be discussing with two experts a Supreme Court case that will be argued next week, RNC versus Watson. This case will impact everyone in the United States. It involves the issue of grace periods for mail-in ballots. So please tune in on April 1st, and thanks so much to everyone for
Mary?
joining us today.
Mary, before you say goodbye, as a point of personal privilege, I just want to say, as everyone knows, Mary is a former president of the American Bar Association, and yesterday it was announced that she will be a recipient of the at the annual meeting in August of the ABA of the Commission on Women's prestigious Margaret Brent Women Lawyers of Achievement Award. So well deserved, and congratulations to you, Mary.
Congratulations,
Thank
Mary.
you. Thank you, Lauren. Coming from a past winner of the award. Well, thank you
We're
everyone
excited
for
for you.
joining us today. We hope this webinar has been helpful. And like I said, all the resources will be sent out in an email. So thank you so much, and hope to have you join us on April 1st. Thank you.
Take care, Mary.
Thank you.
Yeah.
Bye, everyone.